Thank you, Mark. My name is François Marier. I'm a manager at Transport Canada. I'll be doing my presentation mostly in English, but if you have questions in French, I'll be happy to answer in French.
Policy. So I'm not a lawyer, and I am, for the lawyers in the room, something far worse for you. I'm the client. But for our, because I'm manager at Transport Canada, responsible for the policy behind all of what we've been talking about today. And I'm going to talk to you about some recent changes that were made to the Marine Liability Act, and also going to talk to you about another piece of legislation which has been alluded to a couple of times, and this is the Wrecked, Abandoned, or Hazardous Vessels Act, with the very fun acronym of WAVA, that is going to come into force soon, and I'm going to talk about what it means, what all this means for the Ship Soil Pollution Fund. Okay. Right. So a little bit of context. The Oceans Protection Plan, which my Associate Deputy Minister mentioned this morning, announced in November of 2016, investing an unprecedented investment of $1.5 billion nationally to improve maritime safety, responsible shipping, protect our environment, engage with Indigenous communities, coastal communities. And part of that was a couple of legislative packages. The first one deals with the Marine Liability Act and the Canada Shipping Act, 2001. And the other one was the introduction of new legislation, which the Mayor has alluded to as well, and that's the Wrecked, Abandoned, and Hazardous Vessels Act, which deals with the issues around abandonment of vessels, derelict vessels, and wrecked vessels. Okay, so this is the overview of the Marine Liability Act changes in particular that I'm going to go through. So there are 7 elements here, and these represent what we like to say are the biggest changes to the fund in the last 30 years. And these amendments will have a major impact on victims of oil pollution, but for the better in terms of enhancing the fund and making compensation available to claimants who need it. As we heard throughout the day so far, the fund has evolved, and its predecessor, which was created in 1971, was first and foremost a fund of last resort. You had to go through all of the others who may be liable to try to get your money before you went to the fund. Well, that was changed when it was realized that from a policy standpoint, does that really make sense? Do we really need to force victims of oil pollution who may not be able to recover from the ship owner? Because as we've heard, sometimes the ship owner is nowhere to be found, is unknown, has no assets, has no insurance. So what do we do in those kinds of situations? And a situation where the IOPC funds, which Canada is a proud member of, is not involved because it's not a tanker spill, right? So we then came up with the fund being a fund of first resort. Say, okay, you as the claimant, you don't have to go through all of those people in order to get your compensation. You can bypass everyone and go directly to the fund. Now, there's a policy question here. The policy question was, well, those who pay into the fund, right, who are the cargo owners, so the people who own the oil and are putting the oil on that ship and have no role in how that ship is managed, how that ship is run, once that ship goes, the polluter is not the guy who owns the oil, it's the guy who owns the ship. Is it fair for them to put up that, to be first liable? And we said from a policy standpoint, in order to be able to ensure that victims got some form of compensation, yes, that we needed to ensure that there was a fund of first resort there. So that was a change that was made a long time ago. But the fact is that nothing stays static. And with the Oceans Protection Plan, we looked at it and we said, well, there is a number of other changes that we needed to make in order to be able to make the fund a world-class fund and a fund that can compensate victims quickly and in an unlimited fashion. Which brings me to the first major change that was made. So, as we heard, there was a limit of liability that existed on the fund. That was about $175 million as of the last fiscal year. But that's now been removed, meaning that the fund can pay an unlimited amount of money if there's a need to do so. And I stress if there's a need to do so, because in its history, not only going back 30 years, but going back to 1971, the fund has never come close to its limit of liability in terms of how much money it's paid out for a single incident. And that's simply because, knock on wood, we've never had a major incident in Canada that's brought us close to that amount to begin with. But in the event that there was such an incident, because my crystal ball is not any better than your crystal ball, and you never know, right? Claimants can now receive 100% of their admissible assessed claims. The word admissible here is important. So no need for prorating of claims like we've seen in other major incidents that have happened in other parts of the world. If there's a significant oil pollution where all of the big limits, we heard about $1 billion being available from the IOPC funds and through the ship owner's liability. Right? It is a lot of money, but in the event that we go past those amounts, then we have a ship oil pollution fund that can provide an unlimited amount of compensation. So the balance of the fund, as we heard, today stands at about $408 million. That's how much money is in the kitty and how much money would be available. Now, it's important to remember that not all of this is all paid at the same time. It takes, first of all, there's a 2-year time bar. It takes a while for these things to be paid out and assessed. So it's not like it's going to spend $408 million like that, right? But if it happened to be drawn down, there is now the ability for the Minister of Finance to grant a loan to the fund from the Consolidated Revenue Fund, and that loan would be repaid through the reimposing of a levy, potentially a special levy, an additional levy on the receivers and the exporters of oil in Canada. So it's not free money. It's money that would be loaned to the fund with conditions imposed by the Minister of Finance, and that loan would be repaid through the levy. The same idea already exists with the rail fund that was instituted, 3 years ago, I believe. So the same concept already exists, as well as under the National Energy Board Act for pipelines. Second thing that we did is, and for the accountants in the room, you're going to love this one, is we changed the levy. Now, we have a levy that it's a statutory levy. And there was a question earlier about, well, who could impose the levy and why was the levy not imposed and what's going on with that? Yes, it's true. The levy has not been imposed since 1976. The reason is because, well, there was some seed money paid into the fund by the industry. And as we saw through Ms. Laga's presentation, that money has grown through the payment of interest. Right? And today at $408 million. But the levy was done on a per shipment basis. So every 300 tons of oil. So if you had a shipment of 300 tons of oil, you had to pay a levy. And back in the early 70s, when this was being collected, the guy down at the dock, you had a piece of paper. You say, okay, this is how much I brought in. This is how much my levy is. And then the revenue agency was the one who collected it. And yeah, there you go. You had $36 million after 3 years of collecting the levy. Well, it doesn't really work today. If we were to try to collect the levy under the old system, who are the people who have to pay this levy? We don't know, because we don't collect that information. We don't know who they are. So we needed to change the system. So we went to an annual levy, aligned it with the international obligations, because as a member of the fund, we have to collect information from those who are importing oil and those who are moving oil domestically by ship. We have to collect that information and say, okay, so how much are you moving by year? Are you above these thresholds? and you have to report that information, and then we pass that information along to the fund. So we say, okay, well, it only makes sense that that's going to be the levy to the SOPF as well. But what's unique in the Canadian context, in the international conventions, it's only those who are receiving oil. Because long, long ago, when the conventions were being negotiated, it was determined that, well, the person who's economically benefiting from the movement of oil is the person importing the oil, right? The person buying the oil, the person bringing that oil in. So the levy on the international funds is only levied on oil being received, oil being imported, and oil being moved around domestically, if it's a coastal movement, let's say. But in Canada, that doesn't necessarily work because we also have oil that's exported out of Canada. And because you're now dealing with a much smaller pool of levies, a smaller pool of contributors, well, you need to widen that because your risk is not only on the oil coming into the country and the oil that might be moving around to different communities by ship, but it's also the oil that would be exported from Canada. And it's not just crude oil, it's any kind of oil. So it's crude oil, fuel oil, refined products, you name it. This is what the levy would be if it were ever to be reimposed by the Minister of Transport. The Minister of Transport is the person that would reimpose the levy. It would be on all of those oils. So we try to capture all of it, right? Now the next one was another policy change that was made, and this was to be able to give greater authorities, particularly to the Minister of Fisheries and Oceans, the Canadian Coast Guard. The Canada Shipping Act 2001 had in it authorities for the Canadian Coast Guard to be able to respond to an incident when there was likely to be a threat of pollution. So here we're really talking about there might not be a spill yet, there is a threat of a spill, and how likely is that threat? How big is that threat? Where is the ship? What's it doing? Where is it going? Is it disabled? Is it drifting? All of those kinds of things, right? So there's no perfect science around this. There's no checklist that you would go down, but right, there was those authorities. But the decision was made from a policy standpoint that we needed to ensure that the authorities were the broadest possible. That likely, okay, that's pretty good, but may is even better. We need to ensure that the Canadian Coast Guard and the Ministry of Fisheries and Oceans is able to respond when there may be a threat of pollution. So from a compensation standpoint and a liability standpoint, this presented a challenge. Because when you're dealing with the liability of the ship owner, well, the liability of the ship owner is limited when there's a grave and imminent threat of pollution. And that's a convention say that. It's very clear, black and white. You can't hold the ship owner more liable than that, than only if there's a grave and imminent threat of pollution. Okay, so what do? Well, we have a domestic fund. We have a domestic fund that is there to step in and to be able to deal with those kinds of situations when there may be a threat of pollution. So this allows compensation for reasonable costs. Again, the word reasonable here is important. Under these new authorities. And it ensures the liability of the ship owner and of the IOPC funds remains unchanged. But that what we're dealing with now is a situation where, yes, the fund may be liable in a situation where there may be a threat of pollution. And does the polluter pay principle, as David was talking about, does the polluter pay principle still apply? Well, it depends on what's your definition of polluter pay. All right, here's the fourth one. Now, we also recognize that there may be situations, in a major oil spill in particular, that there may be the need to outlay significant resources upfront. And that often, or from the Canadian Coast Guard and those responders are not funded for this, right? They don't have all of this equipment laying around. They don't have all of this money laying around to be able to outlay significant resources. So we have a fund that would be able to provide emergency funds to the Canadian Coast Guard in the case of a significant oil spill. So, see, I bolded it, underlined it, bolded it, and underlined it. Significant oil spill. Oil incident, sorry, not spill, incident. So the Minister of Transport can direct the administrator to release up to $10 million upon the request of the Minister of Fisheries and Oceans. So that's like that, could release up to $10 million to say, okay, here you are. There's resources that you can go now and deal with this incident. Right? Should the amount proven to be insufficient, the administrator could be directed to release another $50 million. So I want to talk about $60 million by the Governor and Council. So you need to go above now the Minister of Transport. You need to go to Cabinet, right, to get the Governor and Council to agree to release another up to $50 million. So $60 million in order to deal with a significant tanker spill or oil spill in Canadian waters is a substantial amount of money to be able to inject into a response where you need those kinds of resources up front, and especially when you have a situation where you may not have a ship owner that is backed by, let's say, the clubs, who may not be able to outlay that kind of money up front. And then the Coast Guard would then use the fund to respond and compensate third parties that are under their direction. And then the emergency funding, it would be part of a claims process, or it would be reimbursed back to the fund if they get it back from the ship owner. The next one was also mentioned already, and this is an expedited small claims process. So about 75% of claims to the fund are considered to be small claims. And these are claims that are $35,000 and under. And we decided from a policy standpoint to say, okay, there's got to be an expedited way in order to be able to file these claims, much like you file your taxes today. You file your income tax. If you're Canadian, you file your income tax and you file it online. So you go on the website, TurboTax or whatever you use, and then you file all your income tax. Do you have to submit anything? No. No receipts, no evidence, no nothing. You attest that you have all of this information. Should the Canada Revenue Agency come knocking on your door and say, okay, now show me your receipts for medical expenses and child care and blah, 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 right? Well, this works in the same kind of way, right? That you have now a statutory small claims process set out in the Act that is on an attestation basis that allows the claimant to get their money quickly without providing any documentation up front, but by attesting that they fit this criteria and that they have the documentation should the administrator come asking for it. And the administrator can raise that amount to $50,000 if she's faced with a significant oil incident. And this is important because in the experience of the internationally, if you look at the Hebe Spirit, and Hebe Spirit, some of you may not know what's a Hebe Spirit. What's a Hebe Spirit? Well, Hebe Spirit is a tanker. It's a tanker that got hit by a barge off the coast of Korea in 2007. This is the largest oil spill, arguably the largest oil spill in the fund's history, larger than the Prestige back in 2002 off the coast of Spain, because it had over 120,000 claimants. Can you imagine having a fund like our fund that has a staff of what, and 12 people, 15 people, maybe? 20, well, okay. So even 20, dealing with 120,000 claims, when the majority of them are probably small, not very well documented, maybe, right? Well, you have now an expedited process to be able to deal with these claims quickly, to get the money into the hands of claimants quickly, and then to deal with it afterwards, right? That's part of the policy here, which is important. So it only covers, though, losses, damage, or costs actually occurred or suffered. It doesn't deal with future losses or what we call pure economic losses. It doesn't deal with those kinds of things. There you actually have to be able to prove something. It also does not apply to responsible organizations. So this is also important because responsible organizations do not have a first resort to the fund. Responsible organizations constituted under the Canada Shipping Act 2001 are representatives of the ship owner, are funded by ship owners, therefore should not have a direct access to the fund. That's a policy of the Canadian government. What is significant incident? Right? What are we talking about when we talk about significant incident? So it's defined as follows. Significant incident means a discharge of oil that due to its severity, size, or location, and due to its impact, actual potential on the environment, requires extraordinary resources to respond to it. 10 minutes, okay. I can do it, Mark. So, important, a discharge of oil, right? So you actually have to have a discharge of oil due to its severity, size, or location. So, yes, you could argue that this is a very broad definition. You could argue that this is a very narrow definition. I guess it really depends if you're a lawyer representing the guys who are going to pay into the fund or the guys who are not going to pay into the fund. I don't know. But we would say that this is a kind of definition that allows the government to be able to say, without coming up with a list that you have to meet X, Y, Z so precisely that you're able to deal with providing emergency funding, emergency funds to the Coast Guard when it's needed, and to allow the administrator to raise the amount of the small claims to $50,000. Pure economic losses. What's a pure economic loss and what does it eat? Well, pure economic loss basically is a loss where you have, you yourself have not been damaged, like your property has not been damaged, right? But you live, let's say, in the vicinity of where a spill occurred, and you've suffered some sort of economic loss. Typically, this happens in the tourism sector or in the fishery sector sometimes. So you're a little bit like twice removed from the actual damage. Canadian courts don't really like to award these kinds of damages. You know, they think that they're too broad, illy defined, not constrained enough. But internationally, they are recognized. There is clear criteria that exist that the IOPC funds and Canada, as a member of the funds, has helped develop and supported. So why shouldn't we also have this in Canada, clearly laid out in the Marine Liability Act to ensure that the administrator, if she receives one of these kinds of claims before the act was amended, say, can I actually pay this, right? Can I actually pay this kind of, I mean, it's not usually recognized in Canada. And what if I get challenged in court and they say, well, no, hold on a minute, you can't pay this, it's not really recognized in Canada. Well, now she can. So the intent here was to clarify that the fund can pay these kinds of losses. So again, a great benefit to the claimant. Oh, and for the bureaucrats in the room and the lawyers in the room, you're going to love administrative monetary penalties because this seems to be the plat du jour for enforcement. So administrative monetary penalties, this is a way to be able to enforce something and act as a deterrent so that you're not negligent in your duties to do things. And we didn't have these under the Act previously, but now we have them, but they're really dealing with the administrative parts of the Act. Because while this may be boring part of the Act in terms of, well, who pays, how do they pay, they report, blah, blah, blah. Well, if you don't have a strong enforcement of that, in terms of you, oil company X, have to report to me each year how much you're bringing in, and you have to then pay me a levy if the levy is reimposed, and you have to keep accounts, and I can go look under, in your ledger to find that out and all that kind of stuff. Now we have administrative monetary penalties that act as a deterrent for making sure that you are compliant with the Act. Okay, so moving on now to WAVA. What does WAVA do? I love that acronym, WAVA. Aims to protect the marine environment, coastal communities from the burden of wrecked, abandoned, dilapidated hazardous vessels. So it prohibits vessel abandonment. So this is for the first time in Canadian law, we now have a prohibition against vessel abandonment, except if it's permitted under another law. It really prohibits irresponsible vessel management. It enables the federal government to take proactive measures or action on what we call vessels of concern. So these are vessels that are dilapidated or derelict or at risk of becoming so. It also includes the cargo on board. So all of those pretty pictures of the Farley Mowat, well, some of these powers would now allow the government to 5 minutes. Okay, to deal with the Farley Mowat in a much more expedited way. It also brings into Canadian law a new international convention, the Nairobi International Convention on the Removal of Wrecks. So on that, Wreck Removal Convention. So the Wreck Removal Convention is a convention that essentially sets out two things. It deals with an operational, so when you have a wreck in Canadian waters that is a result of a maritime casualty, fancy term for meaning a grounding or a collision or something, right? So if you have a wreck that happens in Canadian waters, this convention now sets out what are the rights of all the people involved. The ship owner, the flag state, the coastal state, all of these people, right? So it says from an operational standpoint, it has obligations around reporting, marking, locating, removing wrecks, gives powers to coastal state authorities to be able to conduct what's called a hazard assessment in order to be able to determine, okay, so what do you need to do with this wreck, right? Is it good enough to mark it, or do we need to actually remove it, right? And how, and all those things. But it also imposes strict liability on the owner of the wreck. So gone are the days of the ship owner walking away from a wreck, knowing that if it was a club, they wouldn't necessarily walk away. But now, we actually now have statutory strict liability on the owner of a wreck. So we have new powers for the Canadian Coast Guard in order to be able to do the operational aspects of it, including doing the hazard assessment and the locating, marking, and removing of the wreck. It also has, and the liability portions, which I mentioned. So now strictly liable. There is no limit of liability on the owner of the wreck. So when Canada ratified another convention that has not really been mentioned today, but it's a convention called the Limitation of Liability for Maritime Claims, which basically means that as a ship owner, you have the right to limit your liability under international conventions and Canadian law. But Canada has reserved the right not to limit when it comes to wreck removal. It also imposes a compulsory insurance requirement on owners of vessels of 300 gross tons and above, but the insurance is limited to the Limitation Liability Convention. It applies to all Canadian vessels, all foreign vessels that are calling Canadian ports and terminals. It applies in all Canadian waters, and it has direct action. So even if the ship owner is not known or walks away, disappears, you have an insurer that you can pursue. So you don't have to actually have a ship owner. So a few questions, food for thought about MLA versus WAVA. So when is it oil pollution preventive measures or response versus wreck removal or addressing a derelict or abandoned vessels? Where is that gray line? And now that we have WAVA coming into force, where is that line going to be? And under which act are authorities going to, are officials going to act, right? And where's the money going to come from? With the coming into force of WAVA, will there be fewer or more claims to the SOPF? So is the SOPF going to have to continue to pay for derelict and abandoned vessels in the amount that it has? As we heard this morning, it's, what, a third, Anne, is what you're paying? Something like that? 1/3? 1/4. 1/4 is still a lot. And how will cost between the owner and the SOPF be apportioned? And what about situations where you have limited insurance cover that covers both risks? Oil pollution and wreck removal. Not an issue when you're dealing with the P&I clubs. They have dedicated cover for all of these different kinds of risks. But another insurance company that is not a P&I club, less sophisticated insurance company that is just providing some P&I cover for all of your risks, everything from crew to collision. So I hit another boat, I got to pay for his damage. I hit a dock at the same time. I grounded. I had an oil pollution. I lost part of my cargo. All of those things falling under one limitation amount and one insurance cover. How are we going to deal with that, right? Whereas the Wreck Removal Convention and the Bunkers Convention is very clear. The insurance has to be dedicated to wreck removal or to oil pollution. So these are some of the challenges that we may have in the future, but happy to say that we now have a new act that will be coming into force that will, and yes, you're lurking behind me, so thank you.
Thank you very much, François, and please assume your seat. So obviously, since we have a panel, we're not going on the basis of accepting questions just yet. So my next task here, obviously, is to introduce to you the remainder of the panel, the other members. Alors donc, le premier que je vous...
So the first one is Mr. Martin Blouin. He's a former colleague. I've known him for many years. And Martin is probably one of the few people in Canada who devoted almost all of his career to protecting marine environment.
Is our moderator. My colleague Rohan Matai from our office will act as the moderator of this panel. And now I'm very happy to turn the proceedings over to you, and I'll probably be able to grant you an additional 5 minutes or so at the end of the presentation, which will cut into our coffee hour, but in the interests of fullness of time, and I'll leave you to manage the rest of the time.
Thank you, Mr. Gauthier. So hello, everyone. My name is Rohan Mathai, and I'll be moderating this panel. You've just now heard Mr. Marie's presentation. He spoke about the amendments to the Marine Liability Act and the Canada Shipping Act, as well as the new Wrecked, Abandoned, or Hazardous Vessels Act. Now, I'll be asking some questions that are designed to tease out some of the effects of those amendments and some of the rationale for them. And you will have an opportunity to do so as well during the question and answer period. Now, just a note, the panelists are from Transport Canada, the Canadian Coast Guard, and the Office of the Fund Administrator. However, their viewpoints do not necessarily reflect those of the organizations. So now just for clarification, I have, I guess, 25 minutes, 30 minutes? Okay, around that. Okay, so now let's begin. My first question is in regards to Canadian Coast Guard response powers. The Canada Shipping Act provides that the Canadian Coast Guard has a variety of powers, including removal, destruction, disposal, and selling of a vessel and its contents. To that list has now been added dismantlement. Do any of you think that this could result in more eligible claims to the administrator of the fund?
Oui, je vais répondre en français. Ben, le démantèlement est un outil pour...
This is a tool that we can use to dispose of a vehicle. It's a way that we can use to reduce potential damage caused by pollution. So they've added dismantlement, but it doesn't change anything in fact. Well, I agree. We don't really see any change. I can't see how you can dismantle without destroying a ship.
Was already being done, and I think from an operational standpoint, as we heard, it's not going to change anything.
Question now is on when can the Canadian Coast Guard use its response powers? As Mr. Mari's presentation provided, the amended CSA makes it easier for the Canadian Coast Guard to respond to a threat of oil pollution. Previously, there had to be a belief on reasonable grounds that the vessel was likely to discharge an oil pollutant. Now there just needs to be a belief that the vessel may discharge an oil pollutant on reasonable grounds as well. So, Captain Blouin, my first question is for you. Have you ever had a case where it could have been, have you ever had a case where there appeared to be grounds that a vessel may discharge an oil pollutant, but not necessarily was likely to discharge an oil pollutant or a pollutant in general?
Oui, c'est une très bonne question. C'est sûr qu'on peut revenir en arrière.
That's a very good question. So let's look back at the situation of the Rio Orinoco. It was ship at anchor that had problems. When you look at the situation, the weather, the high winds, the place where the ship wanted to drop anchor was inappropriate. So if we could have taken preventive action to stop that ship from anchoring there, which caused the grounding, and then an intervention of $12 million, if we could have acted earlier, it would have reduced the cost. We use this kind of proactive approach much more so than in the past. For example, when certain ships meet ice on the St. Lawrence, we have powers that allow us to analyze the situation. And the fact that the ship is caught in the ice and could drift with the ice will not necessarily cause pollution, but it could. So yes, this change in the Act is very beneficial.
For all of you, but Mr. Cote, perhaps you could start, is what criteria do you think could be relevant in determining whether a vessel is in the category of may discharge a pollutant?
That's an interesting question, and I think one that, is more up to the evidence than it is to the fund. The question is, when can Coast Guard intervene, and how does it discharge the burden that it has to demonstrate that it had the power to do what it did from a compensation perspective? I don't know. I would say that at the end of the day, it's a question of evidence, but it's obvious that though the standard of proof to meet, which is reasonable grounds, is the same, the threshold of may discharge a pollutant obviously should make the Canadian Coast Guard's life easier in terms of being able to access compensation on the back end.
Mr. Marier, Captain Blouin, do you have additional thoughts?
I would just say that from a policy standpoint, it was important to ensure that the act that governs the authorities of the Minister of Fisheries and Oceans is clear in terms of being able to intervene and to act when there may be a threat of pollution, right? To provide that proactive stance if it was warranted. And here we're really talking about preventive measures, right? We're talking about a situation when you even have a drop of oil in the water, right? The same needed to be done on the compensation standpoint. So if you're going to give this authority to the Coast Guard, you had to do the quid pro quo when it comes to the compensation standpoint. You had to give them some avenue in order to be able to recover those costs if they take action under those kinds of circumstances.
Okay. We'll touch on that a little later on the compensation side. Captain Blouin, do you think that this change from likely to may could result in increased response operations or affect the Canadian Coast Guard in other ways?
Ben, je crois pas. Je pense que
Well, I don't believe so. I believe that our protocols are adjusted based on the concerns of society, the governments, and the population. Maybe we extended the elastic, but it is a reality. We have to intervene in a proactive way, and that's beneficial. Pulling a ship can cost $15,000 or $20,000. compared to the grounding, which can cause some millions of dollars in damage. So there's the economic aspect and the social aspect.
As regards to emergency funding of the Canadian Coast Guard response. As Mr. Murray provided in his presentation, the Marine Liability Act now provides that the Canadian Coast Guard can request emergency funds from the MLA, from the Ship Source Oil Pollution Fund, with a maximum initial emergency funding of $10 million. And this would be for costs related to a significant incident. So, Mr. Cote, the Marine Liability Act defines significant incident in respect to severity, size, location of an oil spill requiring an extraordinary resources for response. I guess when do you think an oil spill might, given those factors, when do you think an oil spill, due to its size or location or perhaps other factors, could be a significant incident for the purpose of emergency funding? Perhaps is yours? Okay.
All good. That one works. I think from our perspective, given we're given a consultation role in the question of emergency funding, it will be a question of evidence. It'll be a question of need, and we're not asking for full documentation on the front end. Definitely not, just because the Canadian Coast Guard will not have spent any money. But like a prima facie demonstration of why do I need all of this, and and one of the things that size, location, severity, etc. doesn't cover is, I think, obviously political considerations alone, posturing and that kind of thing.
Okay. Mr. Murray and Captain Blouin, do you have additional thoughts, perhaps on the political posturing? Or
C'est une réponse.
Well, what do you mean by significant? It's difficult to answer that, but we can look at certain circumstances where you need a ship of a certain size that might have a P&I. So either the ship is unknown or has taken insufficient measures. For example, it could be in the Arctic. In the Arctic, it's very difficult to intervene. It could be money that would compensate for certain actions, such as supplying food safety of the native populations, or spend money to go get local people out of the difficult situation. So it's difficult to speak out. We haven't yet used the tool. Very briefly, you have to react immediately after an incident. We'll be talking, and things can be done very quickly.
It's very difficult to go back and to say, well, this incident would have required emergency funding, and this was, I don't think we can do that. I think we have to look forward. And as we heard, and you're absolutely right, that it really depends on the circumstances of the incident in particular. Right? First, you have to have an actual discharge of oil. You have to have something happening that warrants the request for this kind of extraordinary measure, because we can't, because the emergency fund emergency fund provisions are not intended to be something that is used regularly. It is supposed to be for an extraordinary circumstance, right? So, yes, do you have a club that is there and that is already spending a lot of money to put up a lot of resources or not, right? Where is this incident happening? How big is this ship? What kind of oil are we talking about? What kind of impact is it having? And what's important here is that the emergency funding is for response. It is not for anything else. It is not for economic losses. It is not for fisheries. Not for anything like that. It is for response, and only for those kinds of costs. And only the Canadian Coast Guard can access it, and only the Canadian Coast Guard could then provide it to others that it may be directing. So the ship owner cannot access it. The response organization cannot access it. The community cannot come and ask for it themselves. It has to be from the Canadian Coast Guard as the the lead on-scene commander and saying, okay, I have this situation. I have this Panamax tanker that is, on the rocks, and I have a large spill, and we need to do something about this. We need to expend a lot of money to put out resources and to fight the pollution. So yeah, I mean, it's what's important too is can the fund provide the money, right? And that's where the administrator comes in, right?
Well, actually, that can be part of my next question.
Yeah.
Is that the MLA, the Marine Liability Act, provides that the Minister of Transport can authorize funding after consultation with the Administrator of the Fund. Why does the Marine Liability Act provide for that? That there's supposed to be consultation.
So the consultation there is intended to, because the administrator is the person best placed to be able to say, well, what is the situation with the fund? How much money do we have in the fund? What are my liabilities? How many other cases do I have? And then the minister can consult the administrator to say, okay, well, okay, can you give the $10 million to the Coast Guard or not? Right?
Could recoverability be a part of that discussion as well?
I'm sure, yes. I mean, as we deal with the situation, there's probably going to be a list of questions or issues that the minister will want to ask the administrator. It's not just a question of, but yes, recoverability, I think, would be a question as well. But I don't think recoverability would be, I would think, a reason not to grant the funding.
From getting, it's very hard to speculate on what actually could constitute a significant incident.
That's right. I mean, it's.
I mean, well, Captain Blouin, in your experiences, has anything in your past experience you feel like could have constituted a significant incident?
C'est difficile à spéculer sur les accidents passés.
Well, it's very difficult to speculate on past accidents, but $10 million for a significant incident is nothing. We can speak of an incident where it's $1 million per day, $2 million per day, $3 million per day. So that amount is very little. If you're talking of a significant event at the international level where the international fund has to pay, it were huge amounts. So 10 million, there could be errors in compensation and so on. So 10 million is a small amount. If you're referring to a major spill that would cause a lot of damage and a great need for cleanup.
Liability. Mr. Murray, you were going to touch on this a little earlier on. So this question in regards to liability, the Marine Liability Act provides that the fund administrator and the ship owner are liable for the cost of reasonable measures taken in response to an oil spill or threat thereof. This questions in regards to measures taken in response to a threat of an oil spill. Now, the ship owner is liable to provide compensation for measures taken in response to the threat of an oil spill, but only if the threat was grave and imminent. However, the fund administrator is liable regardless of whether the threat was grave and imminent. Now, Mr. Murray, I know in your presentation you said that this is something to do with international harmonization was part of the reason for this. Could you speak further on why the international regime perhaps went that route?
Okay. Well, I guess the way I would answer that question is to say that the international conventions is a fine balance that's been negotiated over a long time, right? When the first Civil Liability Convention was adopted in 1969, I mean, this was a novel idea to first have the polluter pay and to have a strict liability regime with compulsory insurance. I mean, this didn't exist anywhere in the world. It was really the first of its kind. But it's a fine negotiation in terms of being able to strike that balance between the ship owner, who has control over the vessel, but albeit limited control over the vessel, right? As they say, the sea is a perilous place, and you cannot control the sea, right? So then you have also the other party that comes into it, which is the cargo owner, right? And how do you strike that balance? It's a difficult one to answer, but the the conventions decided that grave and imminent threat was the threshold that they wanted to hold the ship owner liable to. And that has worked over the years, as we saw the presentation from the P&I clubs and from the IOPC funds. I mean, they have paid compensation in the billions of dollars in terms of how much has been paid over the years in terms of tanker spills, right? So it's worked well. However, there may be situations where it's not necessarily a grave and imminent threat, but action may still need to be taken before it becomes a grave and imminent.
Okay. Do any of you foresee this resulting in increased payouts, Captain Blouin?
I don't believe so. Our approach has always been the same. We have the responsibility to minimize damage caused by pollution. So we'll always have the same approach. Now, this does reinforce the principle of polluter pay. If the polluter doesn't pay, we have the Canadian Fund that will pay. So this is advantageous. The Canadian Coast Guard is not financed to intervene. So we always try to be reasonable and justified in what we do. If we cannot recover these costs, this will have a direct impact on our services, which are a work of prevention, putting of buoys and work on ice. So we have to reinforce the principle of polluter pays.
Claims, but the additional liability provision, i.e. that the fund will pay for the difference between a threat that is grave and imminent and a threat that isn't, can only be, good news for the Canadian Coast Guard. I say that, but I can't think of a claim since I've been with the fund that has turned on the very issue of grave and imminent versus just grave. That's in the last almost 2 years. But at the end of the day, the assessment will be the same. It's does the Canadian Coast Guard, or has it demonstrated that it had the power to do what it did on the evidence in front of us? And then after that, were the measures taken reasonable and were they incurred at a reasonable cost? That doesn't change.
Do you think it could result in perhaps payouts to ship owners? Perhaps the ship owner, paid for response costs taken in response to a threat of oil pollution damage, and for whatever reason they paid it out, and then they come to the fund saying that, well, threat wasn't grave and imminent, so we're not actually strictly liable. Can you compensate us for those costs?
I'm going to make a contentious point here, and obviously I don't represent the administrator's opinion on this, but I don't think that the ship owner ever has a right to claim directly to the Ship Source Oil Pollution Fund, and I believe that if they want to recover from the fund, they have to bring an action. The ship owner is the polluter. They are the first party liable, and as a result, any payment made to the Canadian Coast Guard is ex gratia, or they're doing it out of their own free will and generosity, or, at the end of the day, they're liable for it. So no, there would be no first recourse direct claim to the fund, but we'll see you in court for the excess.
Any thoughts on that, Mr. Marie?
Well, look, again, I'm not a lawyer, so I'm not going to comment on whether or not this may bring on more claims, but I would just say that, look, yes, under the conventions and under the Act, ship owners have a right to limit their liability. If they bring that action forward where they are limiting their liability, can they recover from the fund? No. I know they can recover from the IOPC funds, but can they recover from the SOPF? I'm not sure if it's actually been done, not that you know of. So is this going to bring about a claim by a bold ship owner that decides, oh, well, hold on a minute. In this, 12-hour period when the ship was 10 miles out at sea, it wasn't grave and imminent threat, and then you sent out, a Coast Guard ship to go and intercept it with a tow and you name it, but then when it got to 5 miles out, oh, well, now it's grave and imminent. I mean, I don't think we're going to have, but you never know. The lawyers are going to have fun with it. I know it.
And if that's the situation they thought they'd be in, presumably they wouldn't pay.
The court needs the cases, so
So at this time, we'll be taking one or two questions from the audience here or online. Now, just a caveat, please focus on the effects and rationale for the legislation. If your comments are outside that scope, or more of if your question's outside that scope, or if it's more of a statement than a question, then please perhaps hold your question for later during the break or during the evening reception.
Okay, so I have two questions from online, and I will ask the two of them, and you can answer to any you like. So, as you know, the fund is liable for pure economic loss. Do recent amendments also make a ship owner liable for such losses? So that's question number one. Question number two is about recent legislative changes. Will they address issue mentioned by Mayor Matatal and David Côté, including Titan boat owner registration and insurance?
Okay. Is it me? Okay. So I would say for the first question on pure economic loss, my response is a ship owner was already liable for it. I mean, the international conventions do not necessarily define pure economic loss. They don't restrict it either. So our view, the Canadian government's view anyways, is that the ship owner and the IOPC funds were already liable for these kinds of things. And we actually have defined criteria. If you go on the IOPC funds website and you look at the claims manual, and I would encourage all of you who are interested in doing this, if you haven't done this already, you could find the defined criteria over pure economic loss and what that is. And it even includes things like, in certain limited areas, action that you've taken to mitigate your loss. So let's say you had to, for example, mitigate economic losses by doing a campaign to promote the fish that is being fished there because it is indeed safe, but the general public thinks it's not. Right? In certain cases, there have been claims paid out on this. So this is pure economic loss. This is not, a situation where your own property has been damaged, but you're kind of twice removed. So our view is that the ship owner was already liable for it. And I don't remember the second question.
I think it was in regard to registration.
Oh, registration. Well, I can't really comment on registration. I mean, this is obviously an area that Transport Canada is very concerned about. There have been consultations that have already taken place around this as part of the vessels of concern work that the Canadian government has been doing and looking at the vessel registry and strengthening the vessel registry and information on ownership. We believe that the new financial security or financial responsibility requirements for RECs is going to improve things significantly. But no, there are no plans to impose sort of general requirements for insurance for vessels.
Are we 1 minute? So I conclude at this point. Okay. Yes.
On significance, if I can. I hear what you say about the difficulty of finding significance, but in practical terms, is there going to be any attempt between the minister's offices and the fund to circumscribe, at least in general terms, what kind of factors may come into play in discussing and consulting as regards significance? MOU of some sort?
Well, I would say that there's nothing formal being planned at the moment. But yes, it is an interesting question to be able to say, okay, so when you're talking about significant and what would come into, what kinds of considerations would be, would you take into account? So I'm not saying the door is shut, but I'm not saying the door is wide open.
Wrong too. If I'm remembering correctly, WAVA's hanging on proclamation, at least in good part. Is there any feeling for when it's going to be proclaimed?
So actually, I failed to mention this, but July 30th. July 30th is the coming into force of WAVA. It's the Governor and Council has proclaimed it already. So and that's because on April 30th, Canada deposited its instrument of accession to the Wreck Removal Convention, and that comes into force 3 months afterward. So we have to bring in the Act into force at the same time as the convention come into force in Canada. So it's July 30th.